Okay. So again, we will continue our discussion on the family code. We have gone through Article 26, one of the grounds for the declaration of nullity of marriage, which is wherein one of the spouses is actually psychologically incapacitated to fulfill his or her marital obligations. Now we go to another ground for the declaration of nullity of marriage. This is provided for in Article 37 of your family code, which provides that marriages between the following are incestuous and void from the beginning, whether relationship between the parties be legitimate or illegitimate. Okay? Tanawa niya, whether legitimate or illegitimate between the ascendants and descendants of any degree, and between brothers and sisters, whether of full or half-blood. Giklaro dire na regardless kung ang imuhang relationship with your ascendants or descendants be legitimate or illegitimate, void na kung magminyo mo, okay? So regardless of the line, basta within the direct line mo sa ascendants, descendants, that's legit, that cannot be, or you are not allowed to marry one another. Kanang brothers and sisters, bisag full or half blood, also are prohibited from marrying one another. And this is also true even if ang inyong relationship is either legitimate or illegitimate. What's the reason for the prohibition of incestuous marriage, man? According to an American jurisprudence, no, incestuous marriages have been universally condemned as grossly indecent, immoral, and inimical to the purity and happiness of the family and the welfare of future generations. So various reasons have been assigned why incestuous marriages should be prohibited, especially those between persons closely related by consanguinity. In the first place, they are abhorrent to the nature not only of civilized men, but of barbarous and civilized people. And in the second place, they tend to confuse kono of the rights and duties incident to family relations. And in addition, science and experience have established beyond cavil that such intermarriages very often result in deficient and degenerate offsprings, which, if occurring to any great extent, would amount to a serious deterioration. Okay? So, mo na gisite nga reason. Also, in addition, according to an American jurisprudence, the genetic race of advising against the marriage of related person is, of course, to prevent the coming together in their offsprings of any deleterious recessive genes. It's been proven by science and experience, no? Nga kung relatives mo, if you are relatives by blood, there is something wrong with the offspring. It's been proven by some studies. So, mo na isa sa daw sa mga reasons. And another reason deals with the social and psychological aspects of an incestuous marriage. Social prohibitions against incest promote the solidarity of the nuclear family. Okay, I hope that's clear. So balik ko na to, tanawan ninyo incestuous marriage, unsa man ang mga ground for incestuous marriage between ascendants and descendants, kanang inyong great, inyong father, grandfather, great-grandfather, great-grandmother, kanang within the direct line, those are your ascendants, pataas, okay? Descendants, imong anak, apo, apostohod, apos lapalapa, kinsa pa nang kutob dira, basta within the same line, regardless of the degree. Bisag ikapila na nimo nga degree, basta within the direct line, you are prohibited from marrying one another. So kaning brothers and sisters, this is already understandable. Another ground for the declaration of nullity of marriage is provided for in your Article 38 of the Family Code. Niingon diha, ang kanipod, ang rason pod ani is public, this is against public policy. Katong una is because it's an incestuous marriage, okay? Kani is by reason of public policy. Unsa man nga mga marriages ang atong gikonsiderar nga void by reason of public policy. Una, kanang marriages between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree. Okay, we will discuss that later on. Collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree, between step parents and stepchildren, between parents-in-law and children-in-law, between the adopting parent and the adopted child, between the surviving spouse of the adopting parent and the adopted child, between the surviving spouse of the adopted child and the adopter, between an adopted child and a legitimate child of the adopter, between adopted children of the same adopter, and between parties where one, with intention to marry the other, killed that other person's spouse or his or her own spouse. Okay. So what's the reason why marriages by reason of public policy is prohibited or are prohibited? Article 38 of the Family Code clearly provides that marriages therein described are against public policy. It is the policy of the state to foster a normal, peaceful, and wholesome, integral nuclear family unit, which would constitute the very foundation of the society. For the state, therefore, the marriages described in Article 38 will not serve the fundamental objective of nurturing a stable family unit that can effectively be the foundation of society. So, following the general rule that only those declared by law as a void marriage should be treated as such, the enumeration here in Article 38 is exclusive. So, kung magpakasal ang guardian o ang iyahang ward, it's allowed because it is not included in the enumeration in Article 38. Also, kanang principal o ang iyahang agent, they can likewise marry each other because they do not suffer from any other impediment provided in the family code. Okay. So, ano yan? Let's start with Article 38, Paragraph 1. Nganong prohibited man ang collateral blood relatives by consanguinity to marry one another. And sa ganitong paragraph 1, it's between collateral blood relatives, whether legitimate or illegitimate, okay? And up to the fourth civil degree of consanguinity. Oh no, wala consanguinity, up to the fourth civil degree ang gibutang dira, okay? So marriage between collateral blood relatives up to the fourth civil degree may disturb the policy of the state as it may likewise result, though not of the same gravity, in the dangers and confusion attendant in incestuous marriages under Article 35. Pertinently, relationship by consanguinity is in itself not capable of dissolution. Hence, the mere fact that a common ascendant, a grandfather, for example, died, does not sever the blood relationship of first cousins. And to determine whether two persons are relative of each other up to the fourth civil degree, they have to consider their nearest and immediate common ascendant. This is what I have been telling you in our preliminary discussions. In order to compute the degree between relatives, no, between relatives, you have first to consider the common ascendant. Kinsa may inyong common ascendant, and then you count the number of relatives from one of them to the common ascendant and from the common ascendant to the other one. Okay, so kani this is found in the book of Santa Maria, no? Let us now consider the blood relation diagram of a person whom we shall designate as Juan Jr. and determine the relationship of Juan Jr. to some other persons within his blood relationship. Okay. So, kaniko no. So, why ko no ninyo guys. Unsa man ang can answer this. Unsa man ang relationship ni or pila man ka degree ang relationship ni Juan Jr. og ni Anita? Anyone? Within within pila man sila ka degree na relative. Juan Jr. and Anita. Can you see the diagram, guys?
Yes, attorney.
Okay, so anyone who can count the degree between Juan Jr., this one, Juan Jr., kani, ay, oo, wait, laser. Okay, kani between Juan Jr. and Anita. Kada. Pila sila ka degree?
Fourth, attorney.
Yes, fourth. Nganong fourth man?
First cousin, attorney.
First cousin. But pila man sila ka degree within how many degree of consanguinity? Kinsay common ascendant ni Junior, ni Juan Junior o ni Anita? Who is their common ascendant?
Lolo Carding.
Lolo
Lolo Carding. Okay, diba? We said before nga in order to count the degree between relatives, you have to consider the immediate common ascendant. The common ascendant is Lolo Carding. Anong na common ascendant siya, guys? Kay?
They have the same lolo.
Yes. Ang ilahang papa nga si Pedro ug si Juan Sr. ang amahan kay si Lolo Carding. So that's their common ascendant. So if you count their degree, that's from Juan Jr. to Juan Sr., that's already 1. Juan Sr. to Lolo Carding, 2. Lolo Carding to Pedro, 3. And Pedro to Anita, that's 4. Okay? Can Juan Jr. and Anita marry one another?
No, attorney.
Kay?
Fourth degree, they're within the fourth degree sa consanguinity. So that's part of prohibition.
Yes, correct. That's in your Article 38, paragraph 1, no? Between collateral blood relatives within the fourth civil degree. Okay. Can you see Jane here? What's the relationship of Jane, or how many degree ang ilahang relationship ni Jane and that of Juan Jr.?
Third degree.
Nganong third man, who is their common denominator, common ascendant?
Si Juan Senior, attorney.
Yes, that's correct. Juan Senior. And if you count from Juan Junior to Juan Senior, that's already 1. And Juan Senior to Julie, the sister of Juan Junior, that's 2. And then Julie to Jane, that's 3. Can Juan Junior and Jane marry one another?
Still no, attorney.
Because still they are within the fourth civil degree. Diba? That's provided in your paragraph 1, article 38. Okay. Now, si Roberta, pila ka degree ang relationship ni Roberta to Juan Jr.?
Fourth degree, attorney.
Kisay common ascendant nila?
Great grandmother and Victoria, attorney.
Yes, Victoria. So you're already very good at this, no? So I think I don't have to further discuss this, but kani, so gikan ni Juan, yung common ascendant, Victoria, because si Victoria is the mother of Lolo Carding and Roberta. So from Juan Jr. to Juan Sr., that's 1 degree. Juan Sr. to Lolo Carding, 2 degree. Lolo Carding to Victoria, 3. And then Victoria to Roberta, that's 4. So still, Juan Jr. and Roberta cannot marry one another. Now, how about Juan Jr. and Dolores? Pila ilahang degree?
5, fifth degree na, attorney.
Fifth degree.
Kinsa ilahang common ascendant?
Si Lolo Carding.
Nganong si Lolo Carding man?
Isiglolo nila. Apo sa tukod.
Okay. So si Juan Jr. to Juan Senior 1, Juan Senior to Lolo Carding to Pedro, that's 3, Pedro to Anita 4, Anita to Dolores 5. Question, can Juan Jr. and Dolores marry one another?
Yes, attorney.
Because they are already beyond the prohibition in Article 38, Paragraph 1, right? Because beyond naman siya sa 4th degree, 5th naman, so pwede na silang makamarry one another. How about Leonor and Juan Jr.? What's their degree or ikapila silang degree of relationship? Can you still hear me?
Yes, attorney.
Yes, attorney.
Okay.
From
So,
Leonard to Juan Jr. attorney, no?
Leonor.
So that's 1, 2, 3,
5
4,
gihapon.
5 gihapon, attorney.
5. 1, 2, 3, 4, 5. Okay. Can Leonor and Juan marry one another?
Yes.
No, attorney.
5th degree. Tigo. 5th degree.
Ingon yes.
No, attorney. Na siya sa Article 37, attorney.
Yes. Juan Jr. cannot marry Leonor, okay? Because in your Article 37, Paragraph 1, niingon man dito nga you cannot or marriage is prohibited between an ascendant and a descendant, regardless of the degree. Okay? So kani, if you can see, straight line man ni siya, gikang Leonor, iyahang, unsa naman niya, pinakalola na, niya Carmela, Victoria, Lolo Carding, Juan Senior, that's a direct line. Okay? Kung count ka within the 4th civil degree of consanguinity, that should be collateral blood relatives. Kisa man ng mga collateral kanang padung sa kilid ba? Kanang imong uyuan, imong igagaw, pag-umangkon, mo na sila. But kung mayong kag ascendants, descendants, kanang mga direct, mo na imong direct line. Okay? Imong papa, imong lolo, imong papa sa imong lolo, papa sa imong great grandmother nga na. So kana sila bisag unsa pa na silang gilayon ana, ascendant man na nimo. So regardless of the degree, di gyud na nimo pwedeng pakaslan. The same is true with the descendant kanang paubos direct line. Anak, apo, apos tuhod, apos lapalapa, apos kiting, unsa pa na dihang mga apo na kadaghan na, you cannot marry those relatives kay direct ang inyong linya. Ang provision nga mo apply ana Article 37 paragraph 1. Pero kung collateral ang imong ipon kutobra sa 4th degree. Kakuha ra mo guys?
Yes, attorney.
Okay. So I think that's clear. Let's now proceed to paragraph 2 and paragraphs 2 and 3 of Article 38. Unsa to'y giingon sa Article 38? Kaning marriages between step-parents and step-children and between parents-in-law and children-in-law. Okay? So step-parents and step-children as well as the parents-in-law and children-in-law are related by affinity. Dili sila related by blood but by law, okay, by virtue of the law. The doctrine of affinity grew out of the canonical maxim that marriage makes husband and wife one. So the husband has the relation by affinity to his wife's blood relatives, and she has to them by consanguinity, vice versa. So affinity is a connection formed by marriage. You become relatives because of marriage, okay? Which places the husband in the same degree of nominal propinquity to the relatives of the wife as that in which she herself stands towards them, and give the wife the same reciprocal connection with the relations of the husband. It is used in contradistinction to consanguinity. It is no real kindred, and affinity arises from marriage, by which each party becomes related to all the consanguine of the other party to the marriage. But in such case, these respective consanguinii do not become related by affinity to each other. So the only marriages by affinity that is prohibited in the family code are marriages between step-parents and stepchildren as well as parents-in-law and children-in-law. It is believed that these kinds of marital relationships, if allowed, can most likely destroy the peacefulness of the family relations and can cause disturbance within the family circle. Also note that the Philippine society is characterized as practicing what has been known as extended families, which have proven most advantageous and beneficial to the society itself. This is especially true with respect to parents-in-law and children-in-law, as it is strongly believed that it would be scandalous for parents-in-law to marry their children-in-law because it is more in keeping with Philippine customs and traditions that parents-in-law treat children-in-law just like their own children and vice versa. So these are basically one of the reasons why we consider marriages between children-in-law and parents-in-law as against public policy, as well as those of step-parents and stepchildren. Note, however, can a stepbrother and a stepsister marry one another? Example, si Nico o si kinsa itong love team ni Nico, si Eva are married. And then si Pedi and Ophil are also married. Now, nagpaanol si Eva and Nico. Their marriage was declared null and void or annulled. The marriage also between Pedi and Ophil was declared annulled. During the marriage of the two couples, they were able to bear children. Ang anak ni Nico ug ni Eva si Cherry, ang anak ni Ophil ug ni Pedi kay si Glenn. Okay? So now, for example, kung si Nico o si Ophil, after the dissolution of their marriages, they would decide to marry one another. And yeah, mahimo na mo ng stepbrother o stepsister si Glenn o si Cherry, no? Question, can Cherry and Glenn marry one another without violating Article 38? Kakuha mo?
Yes, attorney. Dili siya allowed, attorney.
Yes.
Dili allowed?
Wait, attorney.
Parents-in-law
And Section 2 of Article 38, attorney.
Ang kuan ha,
Sorry.
ang magpakasal kasi Cherry o si Glenn.
ang mga
Anak ni Ophil o ni Pedi. Si Cherry, anak ni Nico o ni Eva. Now, pagka-nullify na sa kaminyo ni Nico o ni Eva, o pagka-nullify sa marriage ni Pedi o ni Ophil, nagkaila si Ophil o si Nico. Nagdesider sad sila nga magpakasal sa usag-usa. So doon na sila tagsa-tagsa ka mga anak, si Eva o si Glenn. So ang pangutana, pwedeng magpakasal si Glenn o si Cherry without violating Article 38 of your family code?
Parents.
children-in-law, attorney. Both sides. They are both sides children-in-law.
Children-in-law na sila.
Mag-English.
Between step-parents.
Ang
Step-parents, attorney. Section 2, Article 38.
step-parents ba sila?
Dili man ang magpakasal si Kuan, dili man ang magpakasal si Nico o si kinsa ni si di man magpakasal si Eva o si
Ang anak ra.
ang mga anak nila tagsa-tagsa ka mga anak nila magpakasal cannot be done without violating Article 38. Yes, because they're merely stepbrothers and stepsister, di ba?
Step-brothers.
Di ba kanang nagin kay mo nga igsuon gikan sa imong madrasta mo tawagan na. He becomes your stepbrother or she becomes your stepsister, di ba? It's not among the prohibitions enumerated in Article 38. So you can validly marry one another. Okay? Wala siya included sa prohibition. What's prohibited? Kanang relationship between step parents and stepchildren. Example
Yes, step
naminyo si
step
si kinsa ni si
sa
anak ko ang ganyan si Pedi o si Eva sila nagkaminyo. So nahimong stepchild ni Pedi si Cherry, di ba? Okay. So question, can Pedi and Cherry later on marry one another kung panalitan,
ah,
di ba?
ah. So no attorney. So ma-apply na ang Article 38 in
Okay.
that case since stepchild
Child naman siya,
stepfather. Okay.
So that's what's meant by this kanang between step parents and stepchildren, as well as parents-in-law and children-in-law. Okay? Nakuha mo? Sige. Ato ta sa paragraph 4, 5, 6, 7, and 8. Mauni ang adoptive relationship. Narong spelling. Adoptive relationships. Diba? Ang sa itong nasa paragraph 4, tanawon. Paragraph 4, ningon kanang marriages between adopting parent and the adopted child. Kanang ni-adopt ni mo o ang gi-adopt. Okay, bawal na. Kanang surviving spouse of the adopting parent and the adopted child. So duha imong adopting parents, unya namatay ang isa, unya later on nakadesider mo nga or panalitan o nakadesider mong magpakasal og ang imong adopted child, that cannot be done. Surviving spouse of the adopted child and the adopter, ang imong adopted child doon natoy bana nya namatay karon nakadesider mong magpakasal mo sa imong gi-adopt, that cannot be done. Okay? And then between an adopted child balik-balik. Ang paragraph 6, between the surviving spouse of the adopted child. So panalitan, si A is the adopted child, naa siya'y spouse nga si H, and then namatay si adopted child, left with the adopter. Ang surviving spouse and the adopter cannot marry one another. Okay, that's the prohibition in paragraph 6. Kaning between an adopted child and the legitimate child of the adopter, di po na pwede because you become also, by virtue of the adoption, you become the legitimate child of the adopter. So if you become the legitimate child of the adopter, you become legitimate children of the adopter, become siblings, so that cannot be done. Number 8 is between adopted children of the same adopter. Puro mo gipang adopt because inyong status is igsuon na mo puro in the eyes of the law, hindi mo pwede magpakasal. That's against public policy. Okay? So, the relationship created in adoption is merely limited to one of parent and child. Okay? So, the void marriages in an adoptive relationship are specifically and expressly limited by law to those mentioned in Article 38, paragraphs 4, 5, 6, 7, and 8. Timan ina ninyo. So the adopter cannot marry the adopted and the surviving spouse of the adopted. Okay? The adopted cannot marry any of the following: the adopter, the surviving spouse of the adopter, the legitimate child of the adopter, and the other adopted children of the adopter. It must also be observed that while the adopted is by law not related to the surviving spouse, legitimate child, and other adopted children of the adopter, the law makes an express declaration that they cannot marry each other, as the same will be considered void. Okay? In making these void marriages against public policy, the law seeks to duplicate, insofar as possible, the structure of the natural family, and to ensure that the artificial family will mirror a natural family, not only in terms of legal relationships, but also in the emotional content and social significance of such a relationship. Okay? Nonetheless, since only void marriages are those expressly provided by law, it can be seen that barring any other grounds to make the marriage void as provided in family code, and in line with the legal rule that only relationship created in adoption is one of that parent and child, an adopted can validly marry the following. Pwede rin niyang pakaslan ang parents, illegitimate child, and other relatives, whether consanguinity or affinity of the adopter, because wala man na siya sa enumeration, okay? There is no prohibition against marriages between an adopted and the illegitimate child of the adopter. As such, a marriage will not most likely destroy the tranquility of the family home and the artificial family, because usually, ang illegitimate child, they do not live man in the same house where the adopted child and the legitimate child of the adopter are living. On the other hand, the adopter can also validly marry the legitimate, illegitimate, or adopted child, the natural parent, or other relatives, whether by consanguinity or affinity of the adopted. Okay, kaya wa man po na siya na-appeal sa enumeration in Article 38. It must likewise be observed that since Article 38 qualifies the spouse of either the adopted or the adopter as a surviving spouse, this can only imply that the marriage between the surviving spouse of either the adopted or the adopter has been terminated by death. So kung may surviving spouse, the reason for the termination of their marriage should be death. Okay? So kung ang marriage of the adopter and his or her spouse is judicially nullified or annulled, and barring any other ground to make the marriage void, the adopted can validly marry the previous spouse of the adopter, because such spouse is not a surviving spouse as contemplated by law, but a former spouse who, after the finality of the nullity of marriage or the annulment of their marriage, has become a complete stranger to the adopter. Likewise, the adopter can marry the spouse of the adopted if the marriage of the adopted and his or her spouse were severed by a final judicial nullity or annulment of marriage. Remember, nga kaning mayong kag-surviving spouse, the reason for the termination of their marriage should be death. Okay? So kung namatay na siya ang adopted child or the adopting parent, example, that's where the prohibition lies, okay? Pero kung ang cause sa pag-terminate sa ilang marriage or pag-sever sa ilang kaminyuon is that of a judicial decree of annulment or nullity of marriage, di ni mo apply nga prohibition. Okay, surviving man ang operative word nga gibutang. Okay, I hope klaro lang. So, motto, adoptive relationship. Let's now go to the last paragraph, paragraph 9, intentional killing of the other spouse or of spouse, okay? So, sa paragraph 9, the situation described therein is highly criminal, involving, as it does, grave moral turpitude, destructive not only of the family, but the whole society itself. So indeed, if the guilty spouse can undertake a sinister scheme to kill his or her spouse in order to marry another person and can eventually be successful about it, there's no guarantee that he or she will not do the same evil act again to his or her subsequent spouse, so that he or she can marry again for the third time. So muna gihimong rason, no, that's the wisdom behind the prohibition. Napatay gani ang primero nga spouse, how much more iyang subsequent spouse in order to marry again for the third time. So that's what the drafters of the family code thought of when they wrote Article 38, paragraph 9. However, it must be emphasized that in killing his or her spouse, the guilty party must be animated by an intention to marry another. Okay? And the reason for the killing was obviously, or yeah, kay kung pananglitan, gipatay sa other spouse o gipatay ni H ang iyahang spouse kay nang laki or sige kabit-kabit, suko kay siya. And then iyahang pakaslan ba, for example, ni H ang iyang abogado nga dipinsa niya during sa iyang hearing, that's not part of the prohibition because ang gi-contemplate sa balaod is that ang pagpatay nimo sa imong spouse is of the intention to marry another. Okay? In this instance, di man tumoy yung intention. The reason for the killing was not really for the purpose of marrying the lawyer, but only to make a stop to the promiscuous affairs of the wife. So, mao to'y reason. So, timanin na ninyo, the intention must be to marry another, okay, with the intention to marry the other, kill the other person's spouse, or kill his or her own spouse, okay? And then, okay. According to Justice Kagiwa, there is even no need to have a prior criminal conviction by the court for the killing is required by law, okay? The mere preponderance of evidence is required to prove the killing, and according to him, it can be a unilateral intention and need not be shared by the other spouse, so that even the unknowing party will be affected by the void character of the marriage. Okay? So, dali ra nang hinumduman ang mga grounds under Article 38. Let's now go to Article 39. Okay, Article 39 provides that the action or defense for the declaration of absolute nullity of a marriage shall not prescribe. Okay, dili mo prescribe. This article was amended by Executive Order 227 and RA number 8533, wherein the phrase, however, in case of marriage celebrated before the effectivity of this code and falling under Article 36, such action or defense shall prescribe in 10 years after this code shall have taken effect, has been deleted by the amendatory provision of RA 8533. Okay? So, the time within which to file an action for the declaration of nullity of marriage or to invoke such nullity as a defense, whether in a direct or collateral manner, does not prescribe. Dili mo prescribe. Okay? A judicial decree of nullity of a marriage does not legally dissolve a marriage because such marriage is invalid from the very beginning and therefore being non-existent cannot be dissolved. So the judicial decree merely declares or confirms the voidness, the non-existence, or incipient invalidity of a marriage. Therefore, the decree is known as the Judicial Declaration of Nullity of Marriage. Okay? So, lahi itong annulment decree because you annul a valid and subsisting marriage. Okay? So, kung moingon ka o ang imong ground is provided for in Article 35, 36, 37, 38, what you will file is a petition to declare the nullity, the absolute nullity of your marriage. Okay? Kay wala man kay i-dissolve the marriage in the first place. Kay void naman siya from the very beginning. So what you will ask from the court is to declare it as absolutely null and void. Okay? In the case of Ninyal versus Bayadog, the petition for the declaration of nullity of marriage was filed by the children of the deceased contracting party only after the latter's death. And the Supreme Court ruled that such a petition can still proceed. Ningon na Supreme Court, this is justified because a void marriage is considered as having never to have taken place and will be treated as non-existent by the courts. As such, the petition is imprescriptible and can be filed by the children even after the death of the contracting party, who was their father. The Supreme Court said that if the death of either party would extinguish the cause of action or the ground for defense, then the same cannot be considered imprescriptible, which should not be the case. However, ang Supreme Court in a resolution under Administrative Matter number 02-11-10, which took effect on March 11, 2003, said that ininyal as to prescription does not hold anymore. The ruling ininyal as to the prescription does not hold anymore because the said resolution provides that giklaro na sa rules on the declaration of nullity of marriage nga only the husband and the wife can file the case. And if filed, the case will be closed or terminated if during sa iyahang pendency, either the husband or the wife should die. Okay? Moreover, under the said new rules on declaration of nullity, ang mga heirs cannot anymore file a case for nullity of marriage of their parents or of their parent with their step-parent. Okay? That's what the Supreme Court said in the case of Enrico versus Ailes of Medinaceli. Kay tungod sa pagpasar sa Supreme Court sa AM number 02-11-10, gi-abandon nila ang ruling nila sa Ninyal versus Bayadog nga ang pag-file sa nullity of marriage does not prescribe and anyone can file as long as interested sila in its validity or invalidity. So, kaniadto ang family code, if you can see here in Article 39, silent siya as to who can file for the declaration of nullity of marriage, diba? But with the advent of the Supreme Court's resolution under AM number 2-11-10, only the husband or the wife can now file a court case to declare the said marriage void. Okay, and this has been reiterated also by the Supreme Court in one of its decision in Fujiki versus Marinay, wherein the Supreme Court ruled that when Section 2A states that a petition for absolute nullity of void marriage may be filed solely by the husband and the wife, it refers to the husband or the wife of the subsisting marriage. Okay? Under Article 35, Paragraph 4 of the Family Code, bigamous marriages are void from the very beginning. Thus, the parties in a bigamous marriage are neither the husband nor the wife under the law. So the husband or the wife of the prior subsisting marriage is the one who has the personality to file a petition for declaration of nullity of marriage under Section 2, Paragraph A of AM number 02-11-10. Okay. Let's try to see this case, the Giuliano case, the case of Giuliano Liave versus Republic, decided on March 30, 2011. So according to the Supreme Court, her marriage covered by the Family Code of the Philippines, Estrelleta relies on AM number 02-11-10-SC, which took effect on March 15, 2003, claiming that under Section 2A thereof, only the husband or the wife, to the exclusion of others, may file a petition for declaration of absolute nullity. Therefore, only she and Senator Tamano may directly attack the validity of their own marriage. Estrelleta claims that only the husband or the wife in the void marriage can file a petition for declaration of nullity of marriage. However, this interpretation does not apply if the reason behind the petition is bigamy. In explaining why under AM number 02-11-10-SC, only the spouses may file the petition to the exclusion of compulsory or intestate heirs, we said, or the Supreme Court said, that the rationale of the rules on annulment of voidable marriages and declaration of absolute nullity of void marriages, legal separation and provisional orders, explicates on Section 2A in the following manner. Ingon na Supreme Court, only an aggrieved or injured The spouse may file petitions for annulment of voidable marriages and declaration of absolute nullity of void marriages. Such petitions cannot be filed by the compulsory or intestate heirs of the spouses or by the state. Only an aggrieved or injured spouse may file a petition for annulment of voidable marriages, and again, no, it cannot be filed by the compulsory or intestate heirs. The committee is of the belief that they do not have a legal right to file the petition. Compulsory or intestate heirs have a legal right to do not have the legal right to file the petition. What they have is only inchoate rights prior to the death of their predecessor. And hence, they can only question the validity of marriage of the spouses upon the death of the spouse in a proceeding for the settlement of the estate of the deceased spouse, filed in the regular courts. On the other hand, the concern of the state is to preserve marriage and not to seek its dissolution. Note also that the rationale makes it clear that this particular section in AM number 21110 refers to the aggrieved or injured spouse. If Estrelleta's interpretation is employed, the prior spouse is unjustly precluded from filing an action. Surely this is not what the rule contemplated. So the Supreme Court further said that the subsequent spouse may only be expected to take action if he or she had only discovered during the connubial period that the marriage was bigamous, and especially if the conjugal bliss had already vanished. Should parties in a subsequent marriage benefit from the bigamous marriage, it would not be expected that they would file an action to declare the marriage void, and thus, in such circumstance, the injured spouse who should be given a legal remedy is the one in a subsisting previous marriage. So the latter is clearly the aggrieved party, as the bigamous marriage not only threatens the financial and the property ownership aspect of the prior marriage, but most of all, it also causes an emotional burden to the prior spouse. So the subsequent marriage will always be a reminder of the infidelity of the spouse and the disregard of the prior marriage, which sanctity is provided by the Constitution. Naapoy isa ka kaso wherein the second wife filed a petition for intervention in the declaration of nullity of marriage in the case of Perez versus Court of Appeals, no? So she filed an intervention for the declaration of nullity of marriage case filed by her husband in relation to the husband's first marriage, so Minyo Primero. So the Supreme Court in this case denied such intervention on the ground that the second wife had no legal interest to justify her intervention. The Supreme Court said that since the divorce, in this case, since the divorce obtained by her husband in the Dominican Republic from the first wife to be able to remarry the second wife was not recognized in the Philippines, the Philippine law does not recognize the second marriage of her husband to her. However, a void marriage can still be, di man ilang ni ato ning gi-discuss before nga ang void marriage can still be collaterally attacked by any interested party, but only in the proceeding where the determination of the validity of marriage is necessary to give rise to certain rights or negate certain rights. This can occur, for example, in an intestate proceeding where certain heirs can attack the validity of the marriage of the deceased parent so that the children of the deceased parent can be considered illegitimate for purposes of inheritance. Okay? So that's Article 39, Article 30, or Article 40. Article 40 provides that the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Okay? So if a marriage between two contracting parties is void ab initio, any one of them cannot contract a subsequent valid marriage without a previous judicial declaration of nullity of the previous void marriage. So a subsequent marriage without such judicial declaration of nullity of the previous void marriage is in itself void ab initio in accordance with Article 40. Okay. Also note that insofar as this article is concerned, if a judicial declaration of nullity were obtained and not registered with the local civil registrar, and the liquidation, katong partition, o katong distribution of the properties and the presumptive legitim of the compulsory heirs, no, were not recorded also in the proper registry of the property in accordance with Articles 52 and 53 of the Family Code, kana kung imong subsequent marriage is likewise void ab initio. Ito na balik-balik. So only after the full compliance with Article 52 and 53 can a subsequent valid marriage be entered into. Okay? So even if ang imong first marriage is already declared judicially void, any subsequent marriage may still be declared void because of the failure to comply with Articles 52 and 53. Okay? The reason being, for the sake kuno of good order of the society and for the peace of mind of all the persons concerned, it is generally expedient that the nullity of the marriage should be ascertained and declared by the decree of a court of competent jurisdiction. Another reason why a judicial determination of such marriage ought to be sanctioned is that an opportunity should be given when the evidence is obtainable and the parties leaving to have proof of invalidity of such marriage presented in the form of judicial record so that it cannot be disputed or denied. Okay. Now, kanya ito na po ning tapsingan before. Let's read together Articles 41 and 42. Article 41 provides that a marriage contracted by any person during subsistence of a previous marriage shall be null and void. Maunay general rule, okay? Unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years, and the spouse present has a well-founded belief that the absent spouse was already dead. Okay? In case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. So, timanin ninyong 4 o 2 years. 4 years, 2 years, okay? For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee, without prejudice, of course, to the effect of reappearance of the absent spouse. So, some the effect kung mo reappear siya. The subsequent marriage referred to in the preceding article shall be automatically terminated by the recording of the affidavit of reappearance of the absent spouse, unless there is a judgment annulling the previous marriage or declaring it void ab initio. A sworn statement of the fact and circumstances of reappearance shall be recorded in the civil registry of the residence of the parties to the subsequent marriage at the instance of any interested person, with due notice to the spouses of the subsequent marriage and without prejudice to the fact of reappearance being judicially determined in case such fact is disputed. Okay? So, unsa may pasabot anang term nga well-founded belief. Okay? If you can see here in your Article 41, the present spouse kuno has a well-founded belief that the absent spouse was already dead. Niingon ang Supreme Court, ang requirement aning gitawag nato nga well-founded belief actually depends on the circumstances of the case. Okay? The belief of the present spouse must be the result of proper and honest to goodness inquiries and efforts to ascertain the whereabouts of the absent spouse and whether the absent spouse is still alive or is already dead. The Supreme Court further said that the concept of well-founded belief is exemplified in this case. In the Supreme Court, a Filipino seaman wanted to get a judicial declaration of presumptive death from the court relative to his missing English spouse. So foreigner yung spouse. The Supreme Court ruled that the Filipino seaman failed to conduct a search for the missing wife with such diligence to give rise to a well-founded belief that she was dead. Pertinently, in the Supreme Court, in the case of US versus Bias-Bas, no, this is instructive as to the degree of diligence required in searching for a missing person. Yung Supreme Court, in that case, si defendant Bias-Bas was charged with the crime of bigamy. He set up the defense of good faith belief that his wife had already died, and the court held that the defendant had not exercised due diligence to ascertain the whereabouts of his first wife, noting that while the defendant testified that he had made inquiries concerning the whereabouts of his wife, he fails to state of whom he made such inquiries. So kung moingon ka nga imong gipangita nya nangutana ka sa whereabouts, you need to state and you have to show proof kung kinsa nang imong mga gipangutan-an. Okay? He did not even write to the parents of his first wife, yung Supreme Court, who lived in the province of Pampanga for the purpose of securing information concerning her whereabouts. He admits that he had a suspicion only that his first wife, was dead. He also admits that the only basis of the suspicion was the fact that she had been absent. So going back to the case, katong ganiha, katong seaman, ni ng Supreme Court, the court considers that the investigation allegedly conducted by the respondent in his attempt to ascertain Janet Parker's whereabouts is too sketchy to form the basis of a reasonable or well-founded belief that she was already dead. When he arrived in San Juan Antique after learning of Janet Monica's departure, instead of seeking the help of local authorities or the British Embassy, since English man yung asawa, he secured another seaman's contract and went to London, a vast city of many millions of inhabitants, to look for her. Okay? So in this case, na Supreme Court, there was no showing of a well-founded belief, no, that the absent spouse was already dead. Okay? Also in one case, ningo ng Supreme Court, where the person seeking a judicial declaration presented only the barangay captain but did not only presented the barangay captain but did not present the alleged persons from whom he allegedly made inquiries, and did not even make inquiries with his parents-in-law who knew of his wife's abandonment of the conjugal abode. The Supreme Court ruled that there was failure to prove a well-founded belief that the wife was already dead. Okay. Also note, guys, here, no, in Article 42, kung pananglitan, si absentee spouse mo reappear but does not record his reappearance with the or does not record his affidavit of reappearance, will that automatically terminate the subsequent marriage contracted by the present spouse, the one who declared him or her presumptively dead? Nagpakita buhi man di ay skuan. Buhi man di ay si ex. Okay? Ya, nagminyo nagkaduha si wife by virtue of the judicial declaration of presumptive death of ex. And then a year after, ning reappear si ex. But he did not record his affidavit of reappearance to the local civil registry. Will that terminate the subsequent marriage contracted by the present spouse?
No,
No,
attorney.
no, attorney.
No, ha? That's even reiterated by the Supreme Court in the case of SSS versus Harke, Viuda de Bailon. Yung na Supreme Court, if the absentee reappears but no step is taken to terminate the subsequent marriage, either by affidavit or by court action, such absentee's mere reappearance, even if made known to the spouse in the subsequent marriage, will not terminate such marriage. And since the second marriage had been or has been contracted because of a presumption that the former spouse is dead, such presumption continues in spite of the spouse's physical reappearance. And by fiction of law, he or she must still be regarded as legally an absentee until a subsequent marriage is terminated as provided for by law. Okay? Let's now proceed to Article 43. Okay, what are the effects of a termination of a void marriage? Okay, the termination, of a subsequent marriage, sorry. The effect of Article 41 and 42. So may effect ana, the termination of the subsequent marriage referred to in the preceding article shall produce the following effects. Una, the children of the subsequent marriage conceived prior to its termination shall be considered legitimate. Okay, legitimate yapon na sila. And then the absolute community of property or the conjugal partnerships, as the case may be, shall be dissolved and liquidated. But if either spouse contracted a said marriage in bad faith, his or her share of the net profits of the community property or conjugal partnership property shall be forfeited in favor of the common children. Or if there are none, the children of the guilty spouse by a previous marriage, or in default of the children, the innocent spouse. Okay, so muna effect sa ilahang property nga ma-acquire during that subsequent marriage, either governed by an absolute community of property or conjugal partnership of gains. Pero kung bad faith gani, ang either spouse, no, katong bad faith kay ma-forfeit ang iyahang share to the net profits of the community property or conjugal partnership. And it will be given to the common children, kung way common children, sa children of the guilty spouse by a previous marriage, or kung wa gihapon, adto na sa innocent nga spouse. Okay? And then third, donations by reason of marriage shall remain valid, except that if the donee contracted the marriage in bad faith, such donations made to said donee are revoked by operation of law. Okay? And then the innocent spouse may revoke the designation of other spouse who acted in bad faith as beneficiary in any insurance policy, even if such designation be stipulated as irrevocable. Kaning insurance, usually when we get insurance policies, if we're married, we put as our beneficiary magino atong spouse. So you have the option there to put as revocable or irrevocable. When you put your spouse as a revocable beneficiary, at any time, pwede mo siyang ma-revoke, no? Without the consent of that beneficiary. Pero kung imo siyang ibutang as irrevocable, kailangan, kung naamanggali ka i-add nga additional beneficiary na agin ay consent, mo na effect sa irrevocable nga designation sa beneficiary. Kailangan mo consent yun na imong irrevocable beneficiary. Paitan, i-add ni mo imong anak, i-add ni mo imong mama as beneficiary. You can only add them with the consent of the irrevocable beneficiary who is your spouse. But in this case, kung bad faith si spouse in contracting the subsequent marriage, ang iyahang designation in the insurance policy, bisag irrevocable pa na, will be revoked or maybe, what do you call this? Yeah, may be revoked even if the said designation is stated to be an irrevocable designation. So, mo na'y mahug nga effect if bad faith ka as a spouse. Also, the spouse who contracted a subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate or intestate succession. When we talk about testate succession, mo nang naay mga will, either holographic will or notarial will. Okay? Kana bang naas mga salida nga sa last will and testament. If nagibilin nga will ang decedent, we call that testate succession. If without a will, either holographic or notarial will, we call that as intestate succession. So ang mo-govern ang provision sa balaod on the distribution of the assets of the decedent. So muna na kasabutan. Okay? Now, also remember that if both spouses of a subsequent marriage acted in bad faith, said marriage shall be void ab initio, and all donations by reason of marriage and testamentary dispositions made by one in favor of the other are revoked by operation of law. Okay, so those are the provisions on, or those are the grounds for the declaration of nullity of marriage. Let's now go to the grounds for annulment of marriage. Okay. Article 45 provides that a marriage may be annulled by any of the following causes existing at the time of marriage. Tanawa ning operative phrase, existing at the time of the marriage. Una, that the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21. And the 18 below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party in that order, unless after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. Okay, so kanang between 18 to 21, if you contract a marriage without the consent of your parents, that's considered as an annullable marriage. Okay, except kung after attaining the age of 21, you freely cohabited with the other and both lived as husband and wife. Ikaduhang ground kanang either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband and wife. Ikatulo, kanang that the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. Also, kanang consent of either party was obtained by force, kanang mga vitiated consent, force, intimidation, undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. Kalima, if either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. Ikaunom is either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. Let's read this together with Article 46. Diba, in your Article 45, na-address sa paragraph 3 that the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. Unsa man yung mga fraud nga gipasabot sa balaod? In Article 46 ni ana diri, any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. Una, kanang non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. Concealment by the other party or concealment by the wife of the fact that at the time of the marriage she was pregnant by a man other than her husband. Third, concealment of sexually transmissible disease regardless of its nature existing at the time of the marriage, or concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of the marriage. No other misrepresentation or deceit as to the character, the health, rank, fortune, or chastity shall constitute such fraud as will give grounds for action of annulment of marriage. So what's the reason or the policy consideration for enumerating grounds for annulment of marriage? the drafter said that the state is interested in the permanency of marriage relation. So the preservation of the relation is deemed essential to public welfare. The public policy of the state, which regards marriage as indissoluble and sacred, being the foundation upon which society rests, is to be cautious and strict in granting annulment of marriage. Okay, this state interest finds its expression in the family code provisions exclusively prescribing the grounds for annulment. So timan kaning enumeration in your Article 45, those are just the grounds to declare your marriage as annulled. Okay, so the law favors marriage as the most important of the domestic relations and therefore allows only its dissolution under such restrictions and limitations as the legislature may deem best for the public welfare. As such, in order to annul a marriage, clear and undeniable proof are necessary. Okay? So let's start with this ground, kaning no parental consent. Okay? So the law considers persons of age or of the age of at least 18 years and below 21 years as not possessing the degree of maturity to be able to comprehend thoroughly the consequences and serious responsibilities of marital relations. So kung before sa ilang kaminyoon, gi-require gina sila na they have to obtain parental consent. And any marriage contracted by persons of these ages are required annullable at the instance of the party whose parent, guardian, or person having substitute parental authority did not give his or her consent, and of the parent's guardian or person having substitute parental authority over the party in that order. So the opportunity to annul the marriage exists in the situation so that the probability of a troublesome, ill-advised, or stormy marriage relationship due to unpreparedness of the contracting parties financially, emotionally, and psychologically to enter into such relationship can be terminated or prevented. Also, the age of parental consent limitation provided in the law, of which all, including the youth, is put on notice, was also enacted so that one in the sunlight of youth, standing on the threshold of life, nilit kay pagkastorya sa Supreme Court, standing on the threshold of life, should not walk precipitously into the marriage chamber, but first should look with calm deliberation whether the step is both desirable and safe. In this concept, there has been ample support in aphorism and precept. Certainly, it is based upon common experience and logic. So when you're very young, when you marry at a very young age, you are really protected by law to the effect that you need to seek the consent of your parents in order to show proof nga dili na dinali-dali ang imong pagpakasal. Otherwise, that can be a ground to annul your marriage. Okay? Except, of course, naaliha sa imong phrase, except unless after attaining the age of 21, such party, katong wala naka-obtain of parental consent, freely cohabited with the other, and they both live together as husband and wife. Okay? Kaning unsound mind. So mga unsound mind? To successfully invoke unsoundness of the mind as a ground for annulment, there must be such a derangement of the mind to prevent the party from comprehending the nature of the contract and from giving it to his free and intelligent consent. So, accordingly, the mental incapacity must relate specifically to the contract of marriage in order to affect it. And therefore, any form of mental disease that does not render the afflicted party incapable of understanding or assenting to the marriage contract cannot be used as a basis for attacking the validity of marriage. So, naingon ng Supreme Court nga it is clear that marriages are not invalidated by mere weakness of the mind or dullness of intellect. Kung bugoon yung spouse, di na siya makonsidered as an unsound mind. Okay? Or kanang iyang mga eccentricities or partial dementia. It cannot be considered as an unsound mind. Okay? There has to be a derangement of the mind mo naging sa Supreme Court, to the effect that it would prevent you from understanding the nature of your marital obligations. Okay? Now on to fraud, katong number 3, over which we enumerated unsay mga examples of fraud, diba? So to that the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with another as husband and wife. So under the family code, fraud refers to the non-disclosure or the concealment of certain circumstances which materially affects the essence of marriage. Okay, it pertains to, if you can see this, it pertains to the non-disclosure or either concealment. And awang mga terms gigamit, either by non-disclosure or concealment. Okay, so the circumstances of fraud are limited to those specified in Article 46 of the Family Code. And this enumeration is said to be exclusive. So any act of fraud not included in this article cannot be invoked to annul a marriage. Okay? Notably, in one of the cases decided by the Supreme Court, particularly in Anaya versus Palaruan, niingon ng Supreme Court, kanang non-disclosure sa imong bana sa iyang premarital relationship with another woman, premarital, meaning wa mo na minyo, doon na siya mga kachungkang-chungkang, is not one of the enumerated circumstances that would constitute a ground for fraud. And it is further excluded by the last paragraph of the article, providing that no other misrepresentation, di ba, Monio? No other misrepresentation as to the character, the health, the rank, the the fortune or chastity shall constitute as fraud, as will give grounds to the annulment of marriage. So while a woman may detest such non-disclosure of premarital lewdness, kay kitang mga babae, no, we have this tendency to be very conservative, no, and we want our men to be ganahan ta kita ra jud ilahang first and all that, but it's not always true all the time. So in the Supreme Court, while a woman may detest such non-disclosure of premarital lewdness or feel having been cheated into giving her consent to the marriage, nevertheless, the law does not assuage her grief after his consent or after her consent was solemnly given. For upon marriage, she entered into an institution in which society and not herself alone is interested. Okay? Also, akong giingon ganiha, klaro ka ang giingon sa last paragraph, nga, no other misrepresentation, deceit, character, health, rank, fortune, or chastity shall constitute such fraud as will give grounds to the action for nullity of marriage. And these circumstances are accidental matters, not going into the essence of marriage and not affecting the free consent of the injured party thereto, since it is the duty of the parties to inform themselves of such matters before entering into a contract of such importance to themselves and to the society. Katong akong giingon bitaw nga si Nico kada pamisita ning Eva, lain-lain iyahang sakyanan, okay? And then Eva thought that Nico is very rich, crazy Asian rich siya, kay mga branded, mga luxury cars siyang dalang permi. But later on, Eva discovered that the rank and fortune of Nico is inexistent. Tungod di ay kay, say for example, driver di ay si Nico or iyang papa is driver. So ningon diri ang Article 46 nga no other misrepresentation as to the rank or fortune shall constitute such fraud as will give grounds for action for the nullity of marriage. So mura kag kung palit ka, buyers beware. Ningon ng Supreme Court, when you contract a marriage, it is your duty to inform yourself of such matter before entering into a contract of such importance. Okay? Okay, this will not only the foundation of the family is not only of your interest, but also the interest of the society and that of the state. Okay? And then kaning non-disclosure of previous conviction. Okay? First paragraph ningon diri non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude shall be considered or shall constitute as fraud as referred to in number 3, diba? So to constitute fraud, the party here must have been convicted by final judgment of a crime involving moral turpitude. Example, kanang homicide. That's a crime involving moral turpitude. The reasoning being that moral as here used is tautological and that turpitude as meaning inherent baseness, vileness, or depravity in the private and social duties which a man owes to his fellow men and or to society in general, contrary to accepted rule of right and duty between man and man is comprehended by intentional killing of human life contrary to law. Okay. Under this particular provision, there's a need for a conviction by final judgment. Okay. It is not necessary, however, that one of the parties investigates the other in order to determine whether the latter has a criminal record, and his or her failure to do so will not bar a case for annulment on this ground if it later develops that the party concerned has been convicted for a crime before the marriage. So the burden is on the convicted party to reveal his criminal record. His failure to do so will constitute the non-disclosure. Okay. And then kaning concealment of pregnancy as a fraud. I don't know na ba na biktima ani diri no sa ato ang klase, but the law limits the fraud to the wife only and not to the husband. Okay. The law limits the fraud to the wife and not to the husband. This is because if the wife is pregnant by another man, the husband would be misled in devoting all his attention and care on somebody else's child. And in addition, compared to pregnancy, the fact of the husband's having a child in a concealed prior relationship is speculative and difficult to prove. Okay? So, also remember na ang mere pregnancy alone at the time of the marriage is not sufficient to successfully annul a marriage on this ground. There must be concealment of such pregnancy. Mao na ang imong pangitaon nga word, concealment of such pregnancy. However, if the woman did not expressly inform the man of her pregnancy, but such physical condition was readily apparent to the man, he cannot claim lack of knowledge of such pregnancy. Muna yung hitabo sa bukat versus bukat. Okay? Aning kasuha, ang plaintiff, niingon siya nga he did not even suspect the pregnancy of the defendant. Or ingon siya nga ang pregnancy sa defendant was held to be unbelievable and he did not even suspect it to be unbelievable, it having been proven that the latter was already in the advanced stage of pregnancy, which is already of the 7th month at the time of the marriage. Ako na kaayo. Ako, I'm already 7 months pregnant. So, klaro na jud kaayo, okay? So, the Supreme Court said that pronouncement, however, cannot apply to the case at bar. Here, the defendant wife was alleged to be only more than 4 months pregnant at the time of her marriage to the plaintiff. At that stage, the court is not prepared to say that her pregnancy was readily apparent, especially since she was naturally plump or fat as alleged by the plaintiff. So according to the medical authorities, even if on the 5th month of pregnancy, the enlargement of woman's abdomen is still below the umbilicus. That is to say, the enlargement is limited on the lower part of the abdomen so that it hardly is noticeable and may be noticed, be attributed only to fat formation of the lower part of the body. So, niingon ng Supreme Court, if as claimed by the plaintiff, defendant is naturally plump, he could hardly be expected to know merely by looking whether or not she was pregnant at the time of their marriage, more so because she must have attempted to conceal the true state of affairs. Even physicians and surgeons, with the aid of the woman herself, who shows and gives her subjective and objective symptoms, can only claim positive diagnosis of pregnancy in about 33% to 50% when you're already in the 6-month period. This was actually the case in Aquino versus Deliso. But in Bukat versus Bukat, dili pwedeng moingon diri si Bukat nga there was a concealment because in Bukat, ang iyahang wife has already been 7 months pregnant, and it's very apparent na on the part of the woman, no, on the part of the wife nga pregnant to at time. There was no concealment according to the Supreme Court. As opposed in Aquino versus Deliso na ang babae ani nga time was only 4 months pregnant. There are a lot of women whom I've met na 4 months pregnant na gani pero dili jud maklaro nga pregnant sila. And the Supreme Court said that's true. Most especially sa mga babae nga kanang mga naturally plump, mga medyo chubby-chubby. Sila sa mailhan nga pregnant na sila. So you have to see, no, the distinction. The operative term here is concealment. There has to be concealment. Okay. And then kaning concealment of STD, regardless of its nature, existing at the time of the marriage. Okay. It is enough that there was concealment of sexually transmissible disease at the time of the marriage ceremony to warrant the annulment of such marriage on the ground of fraud. So the fact that the STD fraudulently concealed was of a less virulent character and one that perhaps would be more correctly described as local will not bar this ground. Okay, regardless of its nature, basta mo conceal ka nga na kay STD, that's a ground for annulment of marriage. Okay? Concealment of sexually transmissible disease. Also, ang ikaupat, gamay kayo, no? So, concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of marriage. So, under American jurisprudence, when we talk about habitual drunkenness and habitual intemperance, they are used interchangeably, not to refer to habitual alcoholism and are grounds for divorce dito sa America. And it is submitted that their concept or significance can be used under our jurisdiction as a ground for annulment on the basis of marriage. And although these terms are not susceptible to an exact meaning, they nevertheless have been defined as a persistent habit of becoming intoxicated, and that the nature and the extent of drunkenness must be such that the person, by frequent indulgence, may said to have a fixed and irresistible habit of drunkenness, whereby he has lost the power or will to control his appetite for intoxicating liquor, as where he indulges in the practice of becoming intoxicated whenever temptation is presented and the opportunity offered. Na ako'y maestro sa una, no? In law school, may his soul rest in peace. He already died during the pandemic. He's a habitual drunkard. Kadasod niya sa among klase, he's always drunk. But that's not a ground for annulment of marriage. What makes it a ground for annulment of marriage is concealment. Kung i-conceal na nimo na you are a habitual drunkard, or you are a drug addict, or you're a homosexual, or you're a lesbian, that becomes a ground for annulment. Okay? Kani pong concealment sa homosexuality and lesbianism, this is also a ground for annulment of marriage. Timan nga ang mere habitual alcoholism, homosexuality, that cannot be a ground for annulment. Ground ra na siya sa legal separation, you will see later on. Pero i-conceal ganin na nimo sa imong spouse, mahimo ng ground for annulment. Okay? So, since the very institution of marriage is based on trust and differences of sexes, both in the physical and psychological constitution of the parties, a lesbian or a homosexual who is disposed to have affection towards the same sex to the extent that having relations with the other sex to him or her is repugnant to his or her being may not serve the purpose of law mandating a heterosexual relationship. Homosexuality and lesbianism indicate that questions of sexual identity strike so deeply at one of the most basic elements of marriage, which is the exclusive sexual bond between the spouses. It must, however, be importantly pointed out that ang ground ani is not the homosexuality or lesbianism per se, but the concealment of such sexual orientation. Yun na sa nga homosexual or lesbian ka. But it becomes a ground for annulment as it constitutes fraud kung imo nang i-conceal sa imuhang spouse. Okay? So the element of bad faith on the part of the one making the concealment is essential and must be duly proven. Okay? So that's paragraph 3 of Article 45. Let's now go to Article 45, paragraph 4. The consent is vitiated. Here, in paragraph 4, one of the essential requisites, if you can remember, no, to a valid marriage is the consent freely given by both parties, diba? So kung ang imong consent is obtained or is vitiated because it is obtained by fraud, intimidation, or undue influence, it becomes a ground for annulment of marriage, okay? And remember that it is not necessary that the coercion or force be such as a person of ordinary physical and mental stability would be unable to resist, and that if either party is mentally incapable of resisting the improper pressure applied, there's no consent such as the law requires. So violence constituting duress may either be a physical violence or a moral violence, okay? That is, it may consist of coercion of the person continuing down to the moment of celebration of the marriage, or of the coercion of the will by antecedent threats of bodily harm. So in cunning threats for bodily harm, the person is forced to elect between consenting to marry and exposure to the threatened evils. Okay? Also note that there is an intimidation when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his or her person or property, or upon the person or property of his spouse, decedents, or ascendants to give his consent. So to determine the degree of intimidation, imo po ng sukdon ang age, sex, and condition of the person. Okay? However, ngayon ng Supreme Court in the case of Soto versus Mariano, nga the intimidation that will annul a contract has to do with the evil or harm arising from the unlawful act, not from the exercise of a right, such as the right to a criminal complaint against a person who has committed a crime. Okay, again, in the Supreme Court, the intimidation that will annul a contract has to do with the evil or harm arising from an unlawful act, not from the exercise of a right, such as the right to file a criminal complaint against a person who has committed a crime. Therefore, in the Supreme Court, a threat to prosecute a person for a crime he has committed does not constitute intimidation. A threat to enforce one's claim through competent authority, if the claim is just or legal, does not vitiate consent. Also, where a man who had previous carnal knowledge of a girl married her under the threat to oppose admission to the practice of law, timanin niya, mga lalaki, for immorality, if he did not marry her, he cannot seek the annulment of the marriage on the ground of duress. Okay? Remember this. Kung nakipaghilawas mo sa inyong mga uyab, niya inyong nabuntis, o niya, gihadlok mo niya, nga sige, di ka nimo pakaslon, ako ka isumo sa Supreme Court. And then because of that fear, imo siyang ipakaslan, yung na Supreme Court, that is not a ground for annulment of marriage. Okay? For under existing rules, a man with bad moral character should not be admitted to the bar. However, if the charge of immorality subject of the threat was forced, the marriage can be annulled. Okay? So kung di po to tinuod ang iyahang pagpanghadlok nga di siya buntis baron ng anak, so pwede nga ma-annul ang kaminyoon. Okay? But you cannot say nga, ipugos ra jud ko ano niya, okay, kung di na ko siya pakaslan kay yaman daw kong i-sumbong iya man daw kung isumbong sa Supreme Court para di ko mahimo abogado. So you cannot say that that's a vitiated consent. Okay? There's a question here by Juanito. And siya, how about the wife? How about if the wife really does not know or also believe that the person who impregnated her was her husband? Only later that the husband found out through a DNA test that he was not the father. Is this considered concealment? No, this is not considered concealment because here in this case, si wife Juanito really believe nga siya ang papa, ang iyang bana mo ipapa sa iyahang giminyo. Okay, so it will not constitute as concealment in this particular case. And then we also have another ground here, kaning incapacity to consummate. Atong gisgutan said before nga either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. Okay? So, incapacity to consummate denotes the permanent inability on the part of one of the spouses to perform the complete act of sexual intercourse. Okay? Sexual intercourse. So, during the deliberations of the Civil Code and the Family Code committees, the term impotent and physically were present in the original drafts, no? But were later on deleted to highlight the concept that all types of causes for non-consummation, even if psychological, which leads to physical inability, are included in the provision. However, the term physically was again reincorporated prior to the phrases incapable of consummating the marriage. Okay, so if you can see, either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. Okay, niingon si Justice Kagiwa na the idea here is that either party was physically incapable of consummating the marriage with the other, arising not only from physical causes but also from whatever causes, including psychological causes. Okay. So the word impotent was not reincorporated in the law because ang term here is limited only to males who cannot engage in sexual intercourse. Ang non-consummation actually covers both the husband and the wife, and it can actually be caused by either physical or a structural defect in the anatomy of one of the parties, or it may be due to chronic illness and inhibitions or fears arising in whole or in part from psychophysical conditions. Okay. However, in one of the cases, ningon po tong Supreme Court no nga, merely suffering from epilepsy is not sufficient to show incapacity. Okay. You're welcome, Juanito. Likewise, physical incapability of consummating the marriage cannot be equated to the mere refusal of one party without being physically incapable to engage in sexual intercourse. Also, it must be noted that what is required is physical incapability. Hence, if a husband can attain erection but is psychologically inhibited in engaging in sexual intercourse despite his erection, this situation will not fall under impotency as contemplated in the family code. Okay. And remember nga ang incapacity to consummate the marriage must exist at the time of the marriage ceremony. So in a case where the wife, as a result of an accident which occurred after the marriage ceremony, became paralyzed, which physically incapacitated her from consummating the marriage, it was held that the marriage cannot be annulled as the incapability did not exist at the time of the marriage ceremony. So, dapat it should exist. Klaro man kay na diha sa introductory portion sa Article 45 nga it must exist at the time of the celebration of the marriage. Okay? Also remember that it must be continuous and appears to be incurable. Okay? Kanang mga accidental lang or temporary impotency, it's not enough. And according to the Supreme Court, it has been held that as a ground for annulment of marriage, impotency means permanent and incurable incapacity of one of the parties to the marriage contract to perform the complete act of sexual intercourse. So public policy considerations require that impotency as a ground for either annulment or divorce not encompass temporary or occasional incapacity for sexual intercourse. Okay. Also, there's this one case wherein the firmness and the rigidity of the hymen of the wife cannot easily be opened by natural means, but could be broken by a simple surgical procedure. It was held that annulment on the ground of the wife's incapacity to consummate the marriage cannot be availed of because physical incapability here was not incurable. Pwede mang ma-cure in this case, okay? Naapoy presumption ang balaod, no? Nga the law presumes you to be impotent by virtue of the rule of triennial cohabitation. The presumption of impotence may arise if situation comes within the purview of the rule of triennial cohabitation. This rule postulates that if the wife remains a virgin for at least 3 years from the time the spouses started cohabiting, the spouse or the husband must show that he was not impotent during the said period, and the burden will be upon him to overcome the presumption of impotence. Thus, in a case where the husband claimed that he did not engage in sexual intercourse with his wife, allegedly because such act painfully hurt and distressed the wife, the court rejected the said argument, considering that the wife was found out to be a virgin after 5 years of marriage, and that there was medical finding that she was physically and psychologically normal. And as a result, the court declared the husband incurably impotent, though he was physically normal in other matters. Okay, so muna ang rule on triennial cohabitation. Okay. Also remember that sterility is not impotency. Okay, a sterile person can successfully engage in sexual coition, di ba? Sterility does not imply want of power for copulation. Hence, kaning sterility is not a ground for annulment. But later on, you will see that this can be a ground for legal separation. Okay. Okay. Katong the next is the concealment. The either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. So if the sexually transmissible disease were concealed at the time of the marriage, ari na siya mo fall sa paragraph 3, di ba? It constitutes fraud. And as previously discussed, STD in cases of fraud need not be incurable. Okay? If the STD is not concealed, it can still be a ground for annulment of marriage. But to successfully invoke this ground, ang STD must be found to be serious and incurable. Okay? It must be serious and incurable. Okay? So, in one case, where after 2 months of the marriage ceremony, ang husband contracted syphilis from his wife who had the said sexually transmissible disease at the time of the marriage ceremony, and that while the syphilis temporarily regressed for a time, it again constantly recurred. And in fact, their child who was also born 1 year later, died of a mass of syphilitic sores traceable to the wife, and that subsequently the husband cannot anymore engage in healthy and safe sexual intercourse with the wife without himself again contracting syphilis. The court said that after presentation of relevant evidence, ingon siya nga the chronic syphilis was really grave and in an incurable disease state at the time of the marriage ceremony, which can actually justify the annulment of marriage. Not on the ground of concealment, but because the STD is found to be serious and appeared to be incurable. Okay? If the venerable disease were obtained after the marriage ceremony, it cannot be a ground for annulment. Okay? However, it can be used as evidence for sexual infidelity, which is a ground for legal separation, considering that generally such disease is communicated through sexual contact. Okay? All right. kaning kuan, timan-alang na natong ratification, aning, kay ma-ratify maning annullable marriages, di ba? As previously stated, ang policy gid sa state is to enhance and promote the permanence of marriage. So everything must be undertaken to preserve the marriage and uphold the family as an integral unit of the society. So if there is a circumstance to show that despite the presence of some defects at the time of the marriage ceremony, which would render the marriage annullable, the parties nevertheless subsequently manifest their approval of the marital union, a decree of annulment cannot anymore properly issue. Okay? Under the family code, ang ratification is made if the injured party freely cohabits with the guilty party in the proper situations provided by law. Okay? So, ato ning tan-aw ng mga guidelines. Kung why consent ang parents, guardian, or having substitute parental authority, you can no longer file a suit if after attaining the age of 21, you will freely cohabit with the other and lived as husband and wife. However, kung between pa ka 18 to 21 years of age, even if you freely cohabit with the other, this will not constitute ratification. Okay? It is only the free cohabitation after reaching the age of 21 years of age that it will constitute ratification. Okay? Wata sa na ang 21 aron ma-considered na as ratification. In case of insanity, kung either one of the contracting parties is of unsound mind, after coming to reason, mo freely cohabit siya with the other, nananay ratification. And in this case, ang insane spouse raha ang mo ratify sa free cohabitation. And it must be noted that the sane spouse who knew of the insanity of the other at the time of the marriage ceremony cannot ratify. Also, the subsequent free cohabitation of a sane spouse who had no knowledge of the insanity of the other at the time of the marriage ceremony, but who later on found out of the insanity after the marriage ceremony will not constitute ratification. And he can still file or she can still file an action for annulment of marriage. In this case, ang mo ka-ratify ra gyud kay katurog yung party nga of unsound mind. Okay? In cases of fraud pod, if ang injured party with full knowledge of the facts constituting fraud freely cohabited with the other as husband and wife, there is also ratification. Okay? Okay. Angeline, the concealment only pertains to the pregnancy on the part of the wife, diba? If you can see this, the fraud here, niingon, concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. In this case, I believe lang ha, kay nakasuway na pagpugingan ng case, you can file for declaration of nullity of marriage on the ground of psychological incapacity. If you can prove that your husband is a pathological liar and there's a psychological structure that would connect it to psychological incapacity. So kailangan siyang ma-connect. Otherwise, dili na siya pwedeng mag-ground for annulment of the marriage. I think pwede na siyang mag-ground for declaration of nullity but on the ground provided for in Article 36, which is psychological incapacity. Okay, if you can prove that there's juridical antecedents prior sa inyong kaminyoon, inana na gyud siya kabakakon, hilig siya magtago-tago, ingana, you can prove that sa iyahang pagdako, inana na siya ka mangingilad and all that, di gyud mo disclose o kung sa tinuod. So you can file for nullity of marriage on the ground of psychological incapacity. So judicial antecedents, incurability, and gravity, you have to prove these characteristics. Okay? So ito kung giinganihan, no? Sa cases of fraud, no, kung mo freely cohabit ang injured party. And then in cases also of vitiated consent, same gihapon kung injured party after the disappearance or cessation of the force, intimidation, undue influence, freely cohabited with the other as husband and wife, there is also ratification. Okay? However, if you can see, if the ground relied upon is either the incurable physical incapacity to consummate the marriage by either party, or the affliction of either party with an incurable STD, both existing at the time of the marriage ceremony, the mere free cohabitation as a husband and wife of the parties will not nullify the annullable marriage. Okay? So even if the impotency or incurability of the STD is known to both parties, and then the injured party, or known to the parties prior to the marriage, the injured party can still file a case for annulment on the said grounds. This is so because these grounds are not based on defective consent like the others, but based on the fact that the impotency or disease is incurable. And moreover, they negate the other important purpose of marriage, which is to procreate normal, healthy, and upright relationship. Okay? And however, if the aggrieved parties in these cases do not bring the suit within 5 years after the marriage ceremony, they are barred forever from annulling the marriage. Unlike the declaration of nullity of marriage, which is imprescriptible, ang declaration or ang annulment of marriage has a prescriptive period. Okay? So timan ini kaning 1, 2, 3, 4, it can be ratified, okay, by the free cohabitation of the injured party. Ang 5 and 6, di na siya ma-ratify. Okay? But there is a prescriptive period. Okay? Tanaw na to ang prescriptive period in Article 47. So for causes mentioned in number 1, within 5 years from attaining the age of 21. Okay, 5 years. Dali ra timan-an 5 years ra. Sa number 2, within what's this? Okay, at any time before the death of either party. Okay, so number 2, at any time before the death of either party or by the same spouse during the lucid interval or after regaining sanity. For number 3, katong fraud, 5 years pod after the discovery of fraud. Katong 4, vitiated consent, 5 years from the time the force, intimidation, and undue influence disappeared or ceased. And then for causes mentioned in number 5 and 6, within 5 years after the marriage. So to simplify, natay diagram diri. Okay, so kung why consent, the party who can file is the parent or guardian or the non-consenting party. So if you will file it as the parent or guardian anytime before the non-consenting party reaches the age of 21. If you are the non-consenting party, you have to file it within 5 years after attaining the age of 21. Kung insane, it can be filed by the same spouse without knowledge of the insanity at any time before the death of either party. Kung relative, at any time before the death of either party. Kung insane, during lucid interval or after regaining sanity. Kung fraud, ang maka-file ra kaning fraud, vitiated consent o gatong impotence and STD, incurable STD, injured parties. And same sila o prescriptive period, which is 5 years after discovery of fraud, 5 years from the time of the disappearance or cessation of the force, intimidation, or undue influence. And with respect to the impotency and incurability of sexually transmitted disease within 5 years after the marriage ceremony. Okay? So, taman ilan na ninyong mga prescriptive periods. And then, do we still have time? Okay, kanilang last. In all cases of annulment or declaration of absolute nullity of marriage, the court shall order the prosecuting attorney or fiscal assigned to it to appear in behalf of the state, to take steps to prevent collusion between the parties, and to take care that evidence is not fabricated or suppressed. In the cases referred to in the preceding paragraph, no judgment shall be based upon a stipulation of facts or confession of judgment. We will be discussing the rules on annulment of marriage and the rules on declaration of marriage. How about in passing, in ani ang process kung mo file kag annulment or nullity of marriage. The first is you file the petition. After filing the petition, there will be a service of summons. Okay? So servant of summon ang respondent. And he or she will be given 15 days within which to answer the petition filed with the petitioner. After the lapse of 15 days, kung dili mo tubag ang respondent, the court will order, or even if mutubag siya og answer, no, the court will order the fiscal or the prosecutor to conduct a collusion investigation. We call that collusion investigation. Unsa may pasabot ana? So taon diha ni fiscal kung nagsabot ba ang parties nga magpa-annul sila or nagsabot ba ang parties nga ilang ipa-declare as null and void ang kaminyoon. If masuta sa court nga there was collusion between the parties, the prosecuting attorney can always report to the court and the court can always dismiss the case. So that's basically the result, no, if there's collusion. So during the collusion investigation, the fiscal has to ask, oh, nagkuan mo, saan mo nagstorya sa imong asawa, saan mo nagstorya sa imong bana, nagsabot mo, sa manigasto ani, ana ang mga pangutana, you might think that harmless na, but the effect would be really to find out if there was collusion between the parties, okay? And also to find out if ang evidence presented dili ba fabricated or suppressed, okay? So you will learn that when you become lawyers. Ngayon, ani de, no? Lahi ra akong nabasa sa rules, lahi ra when you practice, because you will have a first-hand experience on how the rules are applied and how the laws are applied when you become lawyers and when you appear on behalf of your clients ngadto sa korte, okay? And then, hindi po na pwede nga there's stipulation of facts or confession of judgments in declaration of nullity of marriage and annulment of marriage. Mag-trial yun na. And then during the pendency of the action and the absence of adequate provisions in a written agreement between the parties or spouses, the court shall provide the support of the spouses and the custody and support of their common children. So the court shall also give paramount consideration to the moral and material welfare of the said children and their choice of parent with whom they wish to remain as provided for in Title 9 of this code. It shall also provide for appropriate visitation rights of the other parents. So kung na sila mga anak, primary consideration gina sa court on saan sila pag-support. Isa may na-custody. O kung usara ang na-custody, the other party will be given visitation rights. So appeal na siya in the decision mo nang during pre-trial, mungutanan ng court, is there an issue on the custody? Is there an issue on the support? Eh kung na, the court will no longer discuss or decide on those matters. Moderate na siya sa ground for nullity of marriage or ground for annulment. Okay? But if na siyang issue, appeal yun na siya in the decision of the court. Okay? And then Article 12 naman. So we will discuss Article 50 next meeting. Thank you very much, Amping.